All right. Good afternoon, everybody, and welcome to this incredible webinar that we have planned for you today. You're going to be learning all about ethics. You're going to be learning all about professionalism, and there couldn't be two better trial lawyers to do that for you today because this is going to be entertaining. It's going to be fun. It's probably going to be one of the best ethics presentations you've ever seen. But I couldn't be happier to have John and Doug with us today. As you guys know, my name is Ginger. I'm the executive director of Connectionology. It's an honor to have you with us. Later on in this webinar, you're going to meet our amazing partners over at HMR, Fox AE, On Point Legal Nurse Consulting, as well as Strategic Relationships. And these amazing companies have been with us since the beginning, helping us continue to be able to do these great webinars for you guys. I wanted to let you know that we are offering CLE credit for this webinar today. It has been approved in Florida for 1 hour of ethics and 1 hour professionalism. And for anybody in all the other states, you'll be able to email me and work with me after this webinar. We will keep track of your attendance and we'll make sure that you get everything you need so you'll be able to get CLE credit in your state as well. And then as far as Florida, it's just going to be a small fee. We figured we'll just find out how many people were interested in getting CLE credit, and then we'll just divide it from there. But work with me after this webinar and we'll get it all taken care of for you guys. I'm going to go ahead and hand this webinar over to Mr. John Romano, and he is going to be introducing Mr. Beam, who is actually the upcoming president for the National Trial Lawyers. It is very exciting. And as you guys know, John, he's also a previous past president of the National Trial Lawyers. And it's great to have both of them all here with us today. Let's have a great webinar. John?
Thank you, Ginger. And again, you do so much for continuing legal education in this country and for our profession. And everybody owes you such a great deal of gratitude. And the work you do for Connectionology is just at the top level in every way. So thank you a million times over, Ginger. I'm very excited about this program, not only because it involves something that is so vital to everything we are doing as a part of our profession, dealing with ethics and professionalism and concepts of integrity and honesty and fair dealing in the way we handle our cases. But we have someone who, just from my perspective, when I think of law students coming out of law school, I want them to be saying, just like the old commercial, I want to be like Mike. They're going to be saying, I want to be like Doug. And I'm going to introduce to you now Doug Beam, who is not only a special lawyer and a special friend, but a special human being. And I've known Doug a long time now. And let me start with this. As a lawyer, he is the total package. He'll go into a courtroom one day and he'll try a robbery case or perhaps a murder case in the criminal court system. Then he'll move to the next building or another courthouse where he'll be trying a traumatic brain injury case or a medical malpractice case. And then in another case, it might be a defamation of character case or a negligent security case. And over the decades, it has been one magnificent verdict after another with Doug Beam. In the law, he's been a teacher. He has been a mentor in every way to literally thousands of lawyers. He has written articles, has provided us with hundreds of speeches and lectures for the top organizations all over the United States on every topic you can imagine in the field of tort law, trial advocacy, and criminal jurisprudence. Leadership-wise, not only a former president of the Brevard County Bar Association, and then he was elected to be the leader of the presidents of all the bar associations for the state of Florida, but now sits in an extraordinary position of responsibility leading all of us as he is president-elect of the National Trial Lawyers, which of course is an organization of almost 20,000 plaintiff lawyers and criminal defense lawyers and employment lawyers throughout America. So his leadership is just, again, extraordinary. Now to the important part. Doug Beam, the human being. You will not find anybody more caring, kind, considerate, respectful, someone who is beyond whatever the definition you may have of a true friend. He is that to so many. I was at an NTL meeting about 3 or 4 years ago, and a young lady who was attending her first meeting, and she was probably 25 years old, she was in tears talking about how she was overwhelmed with emotion just being at that meeting. And I said, what has happened today? And she says, I was in and I got to listen to Mr. Beam speak. And then I went up to him to talk to him, and he was kind enough to walk with me over to an area there in the exhibit hall. And we talked for about 30 minutes. And all he did was talk about me, Mr. Romano. He never said a word about himself. And that is the Doug Beam I know. Right away, trying to make sure that he gets to know a young lawyer and do everything he can to help her, to inspire her, to motivate her. He is just a tremendous dad, a warm and loving husband. And when we talk about ethics and professional responsibility, he is the single most shining example of any lawyer I know in this country who I would put at the top of the pedestal of ethics, integrity, honesty, fair dealing, and dealing in the right way with people. So what an extraordinary honor for me to be doing this program with Doug, and for you all to be able to hear from the great Doug Beam. And Doug, let me turn it over to you now and let you go for a while, and then we'll be going back and forth. Folks, Doug Beam from Melbourne, Florida, President-elect of the National Trial Lawyers. Doug?
Thanks, John. What a kind introduction. I appreciate it so much. When John contacted me, John's the person who came up with the concept of connectionology. I was at a conference and he had it up there, the word connectionology and his definition of it. And I went up to John. I was kind of being a smart aleck. I go up to John and I go, John, that connectionology, boy, that really rolls off the tongue. I said, what's that about? And John goes, Doug, it's about connecting people. It's about what we should be doing as lawyers with each other. And by connecting with each other, we're going to help our clients. So John came up with that concept, and then he ran with it. And around the COVID time, we decided to do webinars. And I think, Ginger, I'll need you to confirm. I don't know if you can chime in here. How many webinars have we done now to date with Connectionology as a team, different speakers? But do you know how many, Ginger?
I don't know if she's right there, but I think, Doug, that we are at somewhere in excess of 400 webinars now.
I think so. I think we are. So,
Yeah.
And the beautiful thing is, it's unusual for there to be any cost associated with attending one of the webinars. Occasionally, there's a small fee if you need to get CLE credit, and that's being offered for that particular webinar. So, John, thank you for the kind comments. It means a lot coming from John. John is in the Trial Lawyers Hall of Fame, past president of the National Trial Lawyers, past president of the Florida Justice Association, past president of the Southern Trial Lawyers Association, board certified trial lawyer. And if you ever get a chance to meet John Romano, you should do it. He has a wonderful wife. He has fantastic children, and just a great human being. So, John, there is one slight criticism I have of your introduction, and that is you keep forgetting when you give me a kind introduction, which you've done over the years. I am a Florida notary public. I just want you to know that. John, it's okay. You keep forgetting
My
it.
apologies. My apologies.
So on professionalism and ethics, ethics, I had a professor at the University of Tennessee where I went to law school, go Vols, big orange country. But I had a professor there who said there's a big difference. He was teaching us professional responsibility It might have also been called jurisprudence, but he said ethics and morals are different. Ethics are established by committees. Sometimes ethics and morals intersect, but sometimes it's just done by a committee. Morals, that's a different ball game in its own right, but it's important. There are differences there. I like to think if you're trying to lead a life with morals, with good morals, which I think we should as lawyers, that the ethics will fall in place. There's rarely an ethical situation that develops that if you follow your morals, that you're going to be okay. So I would first start by saying it's a dangerous environment out there. Justice Ray Ehrlichman of the Florida Supreme Court once told me, Doug, there are two kinds of lawyers: those who have been sued and those who will be sued. And he followed that up by saying they're the lawyers who have been grieved and will be grieved. So we know it's a dangerous environment out there. We have practicing law is a privilege. It's not a right. We have to keep that in mind in our dealings with our respective bar associations. It's a privilege. It can be taken away from you. And I don't know about you, but I worked darn hard to attend law school, graduate from law school, take the bar, pass it. I'm the first lawyer in my family. So in that sense, I consider it a privilege, but it's also by law a privilege. So we must be careful. Also, we're finding in various states that the Supreme Courts are getting more and more draconian in their treatment of lawyers who come before them. If you talk to your bar counsel in your state, I happen to do, John does as well. I have the opportunity and privilege of representing lawyers who are being investigated or prosecuted by the Florida bar. Actually, I helped an out-of-state lawyer recently in a matter he had in another state. And when you talk to bar counsel, they will tell you, we do not want to be in front of the Florida Supreme Court. Generally speaking, they'll tell you that. We don't know exactly what they're going to do, but we know it's generally not going to be something good for the lawyer and, for that matter, bar counsel. So they're uncertain. They know that, at least in Florida, the Florida bar will oftentimes disregard referees' recommendations, the recommendations of the Florida bar, and the recommendations of the attorneys representing the lawyer. So by analogy to the criminal law system, it's as if you've had a change of plea with the judge in the criminal law arena, and you presented it to the court and the court rejects the deal. Well, at least in criminal law, unless it's pleading open to the court, you get the chance to go and have a trial. But the Florida Supreme Court, for instance, changes the deal. That's permanent. That the lawyer has to live with that. So in getting started here, I thought we would talk about today some of the most common things we see that get lawyers in trouble. There are also opportunities to do the right thing. So first of all, one of the most common areas we see lawyers getting in trouble is lack of communication with clients. You must be in communication with your clients. We have case management software now. You can put your deadlines or reminders in your case management program, or if you're a pen and paper person, you can put it on your paper calendar. You need to be talking to your clients. And in our practice, we have a tough, I don't want to call it tough, at least every 30 days, our clients have to be contacted. And when you have our practice, we're a very busy practice, but we're not so busy that we don't talk to our clients at least once every 30 days. And by the way, there's no rule against talking to your clients more than once every 30 days. Clients love to hear from you. And I'm going to give you a few marketing tips. If that's okay, John, I'm going to intersperse it with some marketing.
Yes, sir.
Because, if you don't have cases, You can't make a living and you can't help your clients, right? So marketing tips are, I oftentimes, I don't know about your practices out there, but mine's not a 40-hour job. I work nights, I work weekends. I love what I do. I love my family. My wife and I, Kathy, have been married over 41 years, rolling up on our 42nd anniversary. We have two wonderful children, three wonderful grandchildren, wonderful daughters-in-law. But I work a lot of hours. So one thing you can do is if you can't get to your clients during the workday because you're having so-called workday 9 to 5, because you have hearings and you may be doing potential client interviews, things like that. Uh, I think it's okay to call your client in the evening as long as it's not too late, because the client's very impressed that you're working on their case in the evening. They're even very impressed if you call them on a weekend. I sometimes advise the associates at our office and paralegals, bunch some calls together. Call the client on a Saturday morning, maybe Saturday afternoon. Uh, Keep in mind, if you know your client well enough, you might know if the client, what their personal interests are, if they go to church or synagogue or the mosque or wherever they go. You need to be sensitive to that. You don't want to call them when they're observing their worship, but call them to do that. I know one lawyer, John, used to call me from Paris, and he called me and he goes, Doug, this was early days of cell phones and all of that. It was quite costly to call from Paris. And he would call me and he'd go, Doug, I'm over here in Paris and I'm thinking about that case we're working on together. And just want to let you know I'm thinking about you and we're working. Let's get together and talk. And I go, wow. So I talked to his law partner. I said, John not you, John, another John. John just called me from Paris. And John told me he was thinking about me and our case and just wanted to know how I was doing. And he laughed and he says, he has a special deal in Paris where he goes to this location and he can call for almost nothing. And he calls everyone from Paris, his clients, everybody, and they're going, man, this guy's on vacation and he's calling me. I don't know if that's the same lawyer who used to pay a service to page him in the airports. And so I'd be at an airport and I'd hear this lawyer's name, like John Doe, lawyer John Doe, please come call this number or whatever. And he did that for marketing. But you need to be in touch with your clients. Why is that so important? Well, you might have a lot of cases, but they don't. That case is the biggest thing in their life. They need to know you care about them. They need to know you're working on their case. And you need to tell your paralegals and the lawyers who work with you, keep in mind, if we didn't have that client, we wouldn't be working. We wouldn't be providing, putting food on our table and employing people. The other reason you want to stay in touch with your clients is you need, not only do you get to know them, but I suggest that you go out and visit them. Try to set a time up and go by their house. I would announce my visit, but go out and see and sit with them and look at how they live. See how their house looks. If you have a traumatic brain injury client, for instance, you might find all kinds of things at the house, or you may have a client that always looks great at the house, but they have a traumatic brain injury, and when you go to the house, the house is a mess or something like that. So it's good to go visit your clients, see where they live, see how they do. You can even have a meal with them, something like that. There's nothing against the rules to go visit your client and do that, spend some time with them. It's also nice if they bring people with them when you're communicating with your clients. Have them bring somebody with them, like if maybe if it's a married couple and one of them has a brain injury uh, or or just a catastrophic injury of some sort, have the spouse or significant other come with that person to your office and then let that person tell you what's going on in their lives. And then you might have to talk to that person privately who's with them. You don't want to embarrass your client, but they'll tell you things like, Bob, you forgot to mention, you're not sleeping at night. you're only sleeping 3 hours a night, or you say you're doing great, but you can't move. You don't get out of your chair at home. Or you know what? You're really irritable. People can't stand being around you before it happened. You need that history. It makes you a more effective advocate. So if you talk with your clients, you're less likely to get grieved and you're less likely to have a lawsuit filed against you. Someone once told me it's tough to sue nurses and chiropractors if they commit negligence. Why? Because they actually touch people. A chiropractor will do manipulations on someone. A nurse, he or she will come in and actually touch the person, their arm. How are you doing? They'll listen to them and look at them. It's tough to sue. People don't want to sue them, even though they did terrible things. They had terrible things happen as a result of a negligent act. I will tell you, clients are much more forgiving if you show that you care about them and you're there. Also, clients don't, I think you also have to be careful when you're communicating with clients in social media and in person. You need to keep a professional distance with your clients. Even though you have a lot of compassion and you feel bad for them, you need to keep that distance to be more effective. Um, Examples would be if you get too informal with them, I think they might not respect you quite as much. They expect you to look and act like a lawyer. They expect you to be special. They expect you to take their case seriously. So when we meet with clients, we're not um, too formal, but when we meet with them, we dress the way we would want our clients to see. I dress as if what I would like to see my lawyer look like. Um, and different ways of dressing work for different people. But when your clients come in, uh, treat that as an important event. Set aside time for them. The good Lord gave us 2 ears and 1 mouth. Use your 2 ears. You don't have to talk the whole time, and listen to them and get to know them. Also, clients don't want to think that we have clay feet. They really don't want to hear our problems or our things. We really don't need to get into that on a generally speaking with the clients. They want to think that you're healthy, you're strong, you're clear-headed, you're aggressive, you're thinking about their case and you're working on it. So think about that when you're dealing with your clients. Don't let it get too informal. There's nothing wrong with kidding around with them and talking about sports or music or things like that. But be careful. But the bottom line is the client needs to trust you. If you do make a mistake in the case, you need to communicate that to the client. You want to fix it, but sometimes things happen and you have to tell the client I made a mistake. If you have good communication with your client, the client's going to be less likely to file a grievance against you or to file a malpractice claim, even though sometimes I think lawyers who make the mistakes that result in malpractice, you have to deal with those situations directly and tell your client you made a mistake, even if it is malpractice, because they trust you and they came in. John, in general, I know you and Nancy, your wife, y'all do a lot of traveling uh, together. Nancy's fantastic, works with your firm. But oftentimes, John, I'll call you. It'll be a weeknight, or it'll be during the day, or it'll be on a weekend. And I'll say, "What are you doing?" And you'll tell me, "Hey, I'm over here in a certain part of Florida or in another state. I called you recently. I think you were in Nevada or somewhere, meeting with the client." And I was so impressed by that. What do you think young lawyers, John, can learn about communicating with clients instead of delegating it to support staff? And older lawyers, do you think older lawyers need to be try to be fresh, to stay on top of it, to have that energy level? What do you think, John?
Oh, yeah. Well, number one, there is an epidemic in the legal profession right now with lawyers not meeting with clients. No more initial client interviews with lots of lawyers and clients. Phone contact is paralegal 1, call the client. Paralegal 2, do this with the client. I've had a number of cases that have come into me through one source or another, where I will say to the client, what has been going on with you in your dealings with this attorney or that attorney? And they will say words to this effect: nothing. I haven't seen that lawyer ever, never met him or her. And on other occasions, they'll say there's been a phone call, nothing. So it is a real problem. And it's not just young lawyers. It's also with seasoned veteran lawyers not paying attention to dealing with the client. And Doug, you've heard me say this probably, I don't know, I'll bet 50 times, where I make the point, you have 3 agendas in every case. Number 1 is the agenda of the client. Number 2 is the agenda of the client. Number 3, the agenda of the client. Part of fulfilling that philosophy is talking to the client. So on a rotating basis, whether it be every month or even every 6 weeks or so, communicating with the client is important. Another thing, lawyers are responsible for answering interrogatories, not paralegals. A lawyer can ask a good paralegal to put together the basic answers on what I would call the more administrative details. So if interrogatory number 3 says, list each of the physicians who have rendered care to the plaintiff in the last 10 years, your paralegal can do that, okay? But if interrogatory 4 says, please set forth your version of how the incident occurred, never does that go to a paralegal. That is the lawyer's obligation and responsibility, because that is a strategic answer. There must be tactical thought in putting that together. And sometimes you will see some plaintiff lawyers even put something like this, see accident report. That's unacceptable, obviously. Okay, some judges, we got one judge in West Palm Beach, if you answer an interrogatory like that, he's going to sanction you even if there's no motion for sanctions. Okay, so my point in all this is yes, the lawyer must communicate with the client. And the way you do that is you meet with them in person. And that means you have to get up off your behind and travel to wherever that client may be. On some occasions, the client can come to your office or you meet somewhere else. It means Zoom calls, but not Zoom calls in lieu of an in-person meeting. And it means more regular telephone calls, but it's you as the lawyer. How in the world can you build up rapport, the confidence that the client needs to have in you as the lawyer? How do you build that up if you as the lawyer never have anything to do with the client? You can't. So that's my answer to the question. The lawyer has an obligation to start and to continuously maintain communications with the client, and it must include the lawyer himself or herself communicating directly with the client.
John, let me ask you, so do you think Zoom is helpful, or do you think it's a crutch or bad?
Yeah,
It's hard to beat in person with the client, isn't
it
it?
is. It is. And I will say this, Zoom is not just good, I think it's wonderful. And of course, although we used Zoom somewhat, or video conference calling somewhat pre-COVID, it became huge post-COVID. we use it all the time. But as an example, I have a client in great state where you went to law school at the University of Tennessee. I have a client in Tennessee. After we spoke initially with the client, I made arrangements because I was, it did coincide with another part of a trip I was taking, but I told the client, I need to know exactly where you live. I want to come up and meet you. So I did. We went up and met with the client for a half a day. Now, since then, all of my communications with the client, me and the client personally, have been almost all Zoom calls. Some are phone calls. And in about another, I can't remember what it was, but like about 3 months from now, I'll be back in Tennessee. I'll meet with them in person again. But Zoom is wonderful, but it cannot completely replace the in-person meeting. Okay, it just can't. You just imagine this. Imagine your mom is someone has a mother, and the mother's 70 years old and lives in another state. Yes, you can pick up the phone and say Happy Mother's Day, or maybe a little better, you can do a Zoom call with mom. But imagine what happens if you show up by surprise, you're there in person, to give mom a big hug. Okay? And I know that's a very different example, but the point I'm trying to make, it's so important to do that. Figuratively speaking, clients need to be hugged all the time by lawyers. You know, I would say about 2 or 3 years ago, I had like an epiphany one night, because somebody asked me at a seminar, what is your most important role as a lawyer? And here's what I said, Doug: comforting my clients. Comforting my clients. Because when I meet with them, I want them to feel better about the situation. I want there to be less anxiety. And it's not always going to happen. I recognize that. Look, if I go to the jail and hypothetically I'm meeting with a client, and the next day that client is going to be sentenced to either the death penalty or life in prison, comfort takes on a different meaning, because that's going to be a difficult conversation, a difficult hug, if you will. But to me, that's just very, very important, the way we are doing the communication. So Zoom is good, in person is best, and at some point, I don't care where they live. They can live in the North Pole. You go meet with your client. Are there exceptions? Sure. I mean, if you take a case, you get a call, an out-of-state client, they got hurt in Florida. There's a $100,000 policy. In a matter of days, you're on the phone, you get the case settled for them. Okay, yes, it's true. You don't have to go to Boston to meet them. They don't have to fly and meet you. If that's all there is, and that's what the settlement works out, no, you don't need to go meet them in person. But most cases are not like that. They take on a life of their own.
And don't you think, John, that it's not written anywhere that you have to, how can I put, you can deeply care about your client, even though the client's difficult to care about, if that makes sense. Let me give you an example. I know one gentleman we represent, he's a pretty tough character, John, multiple felony convictions. But I don't know about you, John. My cases, if I have a someone that's been convicted many times of felonies, if you prick them, they bleed just like people who aren't felons. You know, they can get seriously injured in a personal injury situation. But I know with this one guy, I came out and I said, you know, about all I could say about him is when he goes home at night, he doesn't kick his dog. I mean, that's about the, we got work to do here, people. We gotta personalize this guy, in front of that jury. I know, John, you served our country in the United States Marine Corps, and I thank you for that. But what did they do in boot camp about mothers and letters? Didn't they think a personal touch would, what did they tell you in basic training about a letter write? You told me one time, my father told me, he was in the Army Air Force, and they think that's pretty important, that personal kind of connection, right? What did they tell you?
Well, almost everything they told me in boot camp was interlaced with a series of four-letter words, but
Okay.
they affectionately would say this. If the Marine Corps wanted you to have a wife, we would have issued you one.
Oh,
And what they are trying to communicate is the extraordinary duty to country that must be above everything else. On the one hand, that's what they say. On the other hand, the same two drill instructors that I had in boot camp, each one of whom was a hero in the Vietnam War, winning medals for bravery. They had these huge hearts, and they were loaded with a very true sense of empathy and compassion. And they understood how you might have a young man in boot camp reading a letter from his mom and crying. They'd leave him alone. They had an appreciation for that. In other words, they didn't go over and ridicule them over something like that. So I always found that that was one of the beautiful things that I saw in the Marine Corps was the affection that people had for one another. I know there's a different image that Marines like to often portray, but the image that I came away with was it was an organization loaded with people who care, which is, to me, the legal profession. The lawyers that I have spent most of my life running into are lawyers who really care. They're into their families and friends. They care about their employees. They care about their clients. And it's been wonderful. Doug, I have one of our lawyers was helping me here, Michaela, and she provided me with some statistics having to do with ethics and professional responsibility. And I'm squinting here because I had an appointment this morning with the ophthalmologist, and they juiced me with the liquid to, as they say, open up my eyes. But so I've been squinting all day while dealing with that, and it hasn't gone away yet. But listen to this. 20 to 25% of all bar violations, misrepresentation or dishonesty. And this includes dishonesty or fraud on a court or regarding a client, accounting fraud, and other deceitful practices. All right, next. 20 to 25% of all bar violations, neglect or lack of competence. Instances where lawyers fail to provide adequate legal representation, often by missing deadlines or failing to prepare adequately. 10 to 15% of violation are trust account financial violations. 15% confidentiality and conflict of interest. And 5 to 10% outright criminal conduct or moral turpitude. And I had written down earlier something that I just have labeled the 7 deadly sins when dealing with the issues of ethics and professional responsibilities. And if it's all right, let me walk through these quickly. Number one, failure to communicate. For those of us who were your age and my age, we all remember that movie with Paul Newman, Cool Hand Luke, where
Yeah.
he's down in the ditch and they pop him with a shovel or a rifle butt. I forget what it was. And I'll never forget, the guard says, what we have here is a failure to communicate. But it's failing to communicate adequately, timely, continuously, properly with our clients. When they call, we must return the call. We don't say, when they call us, we don't say to a young lawyer, you call him back, or to a paralegal, you call him back, unless it is to say, please let them know I'm in trial. See if it's something where it's okay with them for you to handle. If not, get a number and let them know I will call them tonight. And even though I may only be able to talk 5 minutes because we're in trial, that's what you do. I mean, you've got to do that. All right. Number two, the only way I can put this, deadly sin number two, slacking off and being disorganized. Things like this, missing deadlines, failure to calendar for deadlines, the failing to prepare. I had a circuit court judge in West Palm Beach who I was talking to, this is about maybe 4 years ago when she was running for re-election. And I said, tell me the worst thing about motion practice. You know, motions to dismiss, summary judgment motions, those kind of things. She says, well, the first problem is lawyers failing to get to the point and they just drone on and on and on. She goes, John, virtually all motions, a lawyer can make the points that need to be made in 3 to 5 minutes. But the second thing she said was failure to prepare. And she said, when a lawyer starts talking, it takes a judge about 30 seconds to determine whether or not the lawyer is prepared. And the argument might not be great, or the lawyer might not be whatever else is going on, that's one thing. But the preparation is important to the judge, because when you're prepared, the judge tends to trust you more, to rely upon you more. Number three, this is huge. Failure to stay in your lane. If a person came in right now and said, will you represent me on a landlord-tenant matter? I must say, I don't do that. I'm not qualified to do that. I can't do that. I would try to help them get to somebody who can. If it's patent infringement, I would get them to somebody. If it's wills, probate, estate, guardianship, I would get them to somebody. Family law, divorce, I would get them to somebody. A lot of lawyers make a mistake because a client comes in and says, look, I'll give you a $10,000 retainer right now, but I want you and nobody but you. You can't be thinking, oh God, I could use the 10 grand. So you can't do it. You can't do it. All right, number four, failure to explain the downside and the risks of whatever it is that you're doing in terms of handling the case. Now, let me give you an example. About 3 years ago, some clients came to me from another lawyer. And there was a $100,000 policy and bad injuries. The injuries, arguably, the case was worth $3 or $4 million in terms of the damages. The wife says to me, we are hopeful that you can get the amount that we deserve. And I said, well, what's the amount you deserve? Well, and then they said, we'll just call him, Billy, the first lawyer. Well, he told us that even though there's only $100,000 in insurance, he's going to do some things in the case where after the trial, we will be able to get the whatever it was, $3 or $4 million. After talking to them, obviously they were talking about a bad faith situation. That's crazy. You can't tell a client, I will get you this in the second case. And that leads to all kinds of problems. One thing that just as an item of advice that will help, when we sign up a medical malpractice client, we send a detailed letter explaining the steps in the handling of a medical malpractice case. And we go through statute of limitations, pre-suit notice requirement, everything, so that they understand what's going on. Same thing if it comes to fees. All right. Deadly sin number 5.
Now, John, can we
Yeah.
pause for just a moment because I'm
Yes, we can.
excited to say we have Fox AE and On Point queued up to talk to us for a few moments. Can we take a short break and then pick up with point number 5?
Yes, we can. Perfect.
All right. I'm enjoying this, John. I'm having fun. Who thought ethics and professionalism could be so much fun?
Exactly. And we've got two of the best guys doing this for us. So thank you so much, John and Doug. Up next, we got Patrick with On Point Legal Nurse Consulting. We love this company, you guys. They do some amazing work over there. They got some great staff and nurses. Patrick actually spoke for us yesterday on a very important nursing home abuse topic. So it's amazing to have him back with us today to share some of the great things that they do over there. And I know, John, you rave about their pain and suffering reports. So I can't wait to hear more from Patrick.
Well, thank you. Nice to see you, John. Doug, nice to see you again. Of
Good
course,
seeing you.
I'm actually in Philadelphia, so my background's a little different. I'm getting ready for a deposition tomorrow, so it's always wonderful listening to both of you. You always teach me something, prepare me more for my job that I do over here at On Point and to about other attorneys. So Patrick Stonich, I'm one of the nurse directors over here. I do mostly involved in long-term care. So anything skilled nursing facility related, home health, hospice, and the strange world of community health. I've been a nurse for 20 years. I started here in Philadelphia, and I've been with On Point for about 8 years. Some of the things that we do over here, well, we like to start with merit screening. So we like to start in the beginning of intake as much as we possibly can to get to know the client, as you were just talking about, to get to know the attorneys and to really learn the case so we can walk through you from beginning to end with our nurses and our experts. So we really get to learn the case with you. We do have 3 life care planners on staff. We also have a wonderful group that do our pain and suffering reports, which are the non-economic damage report, excuse me. That report's a little bit different. John talks about it a lot. It's a fantastic report. It just shows a different perspective, not the legal side, and more of a nursing perspective. Patients tend to share a lot of information with nurses that they might not always be so forward with their attorneys sharing. That's what we're there for. We're there to answer those questions. We do a nurse interview. We can go with them if they're going for a medical exam, just to be that other person that can help explain the situation on a different side. We do medical chronologies, organized records. We're really here to help and be an extension of your team. As a nurse, we love to teach, we love to talk, we love to answer questions, and that's what we really like to do over here at On Point. So we're here to help. We're always an email, call, text away, and we'll follow you through to help you out with your cases.
Patrick, great job, and thank you for all of the support from you and from all folks at On Point for Connectionology Seminars of America. But one of the things I wanted to let you know, and I haven't talked to you about this since, but I was just recently in one of the committee meetings for a plaintiff steering committee that I sit on in a multi-district litigation mass tort case. One of the issues is a defendant wants to conduct defense medical exams of the plaintiffs. And part of the discussion was, because I raised it, I said, it is so important that you have a protocol in place when your client is going to go for a defense medical exam. In Florida, we get a court order. Usually it's agreed to, but if not, we go get one. And one of the key components is, I was telling this group, don't go yourself where you might end up getting yourself and your law firm recused. Get a professional legal nurse consultant to accompany your client. And I was telling them all of the wondrous things that the nurse does when the nurse attends the DMA. That's so important. And you've done that for us, you and your firm, many times. The pain and suffering report is extraordinary. I love the interviews when you do the nurse interviews of the plaintiff, especially in the cases where it's like an infant formula NEC case where a nurse does the interview of the plaintiff. We learn so much more. So all of the work that you do is extraordinary. And the great thing about On Point, you are right there at the top. I know there are a lot of legal nurse consulting firms on planet Earth, but there are only a few that are right there at the top of the pillar, the best of the best, and On Point is right there. So thank you again and again for what you do.
Thank you as always. I always appreciate it. And thank you for the presentation today.
And what I love too, for everyone watching, because you are part of Connectionology and our family here, OnPoint is actually offering 10% off of their services, I believe. Is that right, Patrick? For
That's correct.
anybody watching.
Yes, just mention Ginger's name so we'll know that they were sent over for these. Awesome. I mean, Connectionology has been fantastic. The support, the group of individuals that are not only presenting but the other sponsors. We all share stories back and forth. It really is a great group. It's a supportive group. The feedback I got today from yesterday's presentation was amazing, and that's what we're here to help. Yes, there's other placement agencies out there. We help them as well as they help us. We all kind of pitch in to help each other to get the job done. So, but yes, we do have some different pricing structure. So we can accommodate the needs for the firms, whether it's a large firm, smaller firm. We're here to help. That's the most important.
Awesome. Thank you so much, Patrick.
You're welcome.
All right. And I see our good friend Mark is here with us from Fox AE, this amazing company that's also doing great things with animation, demonstratives, graphic design. I mean, they do kind of everything, but they create some of the most realistic images that I've ever seen. So Mark is here to share with us a little more about what they do. Hey, Mark.
Hi, Ginger. Thank you for the introduction. As Julie said, my name is Mark. I'm from Fox AE. We're a team that create graphics and illustrations for all stages of litigation. We work across country with attorneys like John and Doug. We absolutely love them. They were always so kind, and they were a massive help in growing Fox AE. As some of you already know, we launched our stock website recently. The website offers different animations and still shots of various surgeries, injuries, anatomy, and more. Whatever you can find, it's usually there. If you don't find what you're looking for, you can always click here on contact us, send us a brief description, your contact info, and we'll make sure we reach out to help you out, either by creating a stock illustration for you or doing something completely custom depending on your case's needs. I highly suggest you go into view all and just browse out a little bit, sort by date new to old, so you can see the newest stuff we added. We recently added a lot regarding to knees, so like meniscus tears, knee replacement surgeries, debridement surgeries, a lot related to the knees. So that was kind of our latest campaign. We're constantly updating and adding new stuff. So keep an eye on the website. And yeah, that's it for me today. If you have any questions regarding how we develop these graphics, how we can help tell a good story, feel free to reach out. I will add my contact info in the chat. And yeah, Thank you, Ginger. Thank you, John and Doug. It was interesting. I was following from the beginning. So thank you.
Mark, great job. And at our firm, we love working with Fox AE. The work that you all do, the quality is just tremendous. Everybody, they are so responsive. Their pricing is so good, makes so much sense. But what I love is you're not just creative and innovative in the way you are creating and developing these demonstrative aids for all of us, but you're doing it in a far more visionary way. And that to me is so important because you understand the big picture. I had mentioned to this was probably a month or two ago. I told Vicky and Cody that I actually had a physician I was with, and I had an animation and 4 or 5 medical illustrations. When I was done, not only did he say, I totally approve these. Yes, I want to use these in the deposition and then at trial. Right at the very end, he then said to me, would you mind giving me the information for this company? I'd like to contact them to do work for me, because he said that he does speeches to medical doctors around the country. So I put him in touch with Cody, but that's how good their work is, folks. And they're exceptionally responsive. And thank you again, all you do with Connectionology, but great job, Mark. Thank you.
Mark,
Thank you, John.
if I could add, Mark, one thing I think is interesting that Fox AA is doing now for any budget, what you were showing up there, if you're a new lawyer and you want some demonstrative aids at trial, you can do them very inexpensively and get the input of you and Cody and the others on your team about how to utilize it at trial. Then as you are able to develop, maybe these are cases where cost-wise, it doesn't make sense to spend a fortune. But as you progress, then we can get into your animations and these things, and you go all around the country. So y'all have some great ideas. So I just wanted to thank you. And I know your world headquarters is there in Columbia, Missouri, Midwestern. John, they have good Midwestern values. What can I say?
There we go. There we go.
Hey, on that topic, John, we had some on the chat, and thank you, Fox AE. There are some couple good points I just wanted to touch on real quickly. And those of you who are watching, don't be shy. But Susan Staggs of Orlando, she's been part of the dynamic duo with Mark O'Meara for many years. They're a great trial lawyer in Orlando. We were talking about communication with clients, and she makes a good point, John. Tell me what you think. She says, need to be cautious. Let's see. Let me get back. It went down on it. Okay. She says, need to be cautious if you are a lawyer who is active on social media posting, but not responding or communicating with your client regularly. You know, clients check that social media out, John. And if they see you're on a mountaintop in somewhere in the United States or Peru or somewhere, enjoying yourself, and you're posting all of this stuff, they're going to kind of wonder if you're working on their case. You don't have time to talk to them, but you got time to show them things. What's your take on that?
Oh, John, I think you're on mute right now.
There, sorry. The first thing that hits my mind is this. If I'm on a nice trip with my wife, Nancy, and our family, or perhaps friends, the reason I'm able to go on that trip is because of my clients.
Right.
It's because somehow a client came to me or was referred to me. We were able to do a good job. We were able to resolve that case or try it and then resolve it. But somehow it's through the client that a lot of those good things happen or will happen for myself and for my family. So all I can say is that I go back to the agenda of the client. It's just so very, very important. And I do think lawyers need to be careful about all the the crazy braggadocious nonsense that I see from some lawyers. Clients tend to be regular people with regular jobs, and they're working hard, and they're trying to do everything to keep their family together. And if they call on a Wednesday afternoon and you have a receptionist who says, "Oh, Mr. Romano's left for the afternoon," that translates into, he must be playing golf. So you never have a receptionist say something like that. And the key is, I want to make sure that they know we work hard for them. And Doug, I mean, every firm is going to have a different way of doing it. One thing that I've done, you're aware of this, I've done this for, well, as long as I can remember. Every morning when I get up, I go right to my phone and I change the message every single day. Saturdays, Sundays, holiday. And I change it to where I give the day of the week and the date. And here's what I have found. When the clients call, literally dozens and dozens have told me this. In a crazy way, they feel comforted by the fact that that voice they're hearing is from that morning. And they know I'm paying attention to what's going on. I think there are so many little things you can do to let your clients know you're in touch, you're following what they do. If you have a client, just by way of example, who is, I don't know, a big fan of some, let's say a country music star, and you see something on the internet about that country music star, forward that to the client. It takes 30 seconds and just say, "Hey, saw this, thought you might be interested." Got nothing to do with the case directly, but it lets the client know you're thinking about them. So I like doing things like that.
Well, John, I think you were on number 5.
All right. These are deadly sins when it comes to areas of ethics and professional responsibility. So number 5, beware of what I call the veiled threat. You don't threaten other lawyers. You don't threaten other parties. When you talk to them, every communication you make must have one thing in mind. How does this move the ball forward and help my client? If another lawyer's screaming at you, you don't need to scream back. Relax. Don't worry about it. Don't let them control your conduct. Let me give you a couple of examples here. I represented a doctor from a Midwestern state. It's probably been 25 years. And he was charged with a sexual assault of a woman over on the west coast of Florida. And it was a very unique set of circumstances. And she gets a hold of a lawyer who did things that were very questionable. And one of the things that he did early on was, shortly after my doctor was charged with the sexual assault, this lawyer calls me and says, "We would be willing," and he flat out said this, "We would be willing to drop the charges if your client will pay her $200,000. This is like somewhere in the mid-90s. Number one, I hope you all know that's illegal, that's unethical, you can't do that. Number two, If anybody ever calls you with something crazy like that, assume immediately the person is recording the conversation. Assume if they come to you in person and say something like that he or she is wired. But obviously, things like that happen. Most personal injury lawyers at some point in your career, and it might happen several times, you will be approached by the only eyewitness. And that eyewitness will say, "What's in it for me, counselor?" Go back to, I'm being recorded, they're wired, and you know what you've got to say to them. All I'm asking of you, sir, is tell the truth. We cannot pay you, cannot give you anything. And you must do that. So be careful about that. Another thing that,
By the way, John, let me throw something in there. When I do an initial client consultation,
Right.
I don't let them record it, but I also treat it as if I'm being recorded because you don't know what their agenda is. They're telling you what happened and that kind of thing, but I treat it as if that information could go to State Farm Insurance or Allstate or other corporate America. I just treat it. I'm direct with the client. I'm open. I tell them it's confidential. We're not recording it, but I treat it as if I am being recorded because you just don't know these days, John. Just like clients will bring zip drives in or send you attachments. We have a process at our office where we screen that independent of our system in a unique laptop. Reason being, you don't know what they're sending you. It could be bad stuff. You don't know. So I
right.
think I don't want to be ominous, John, but I think you have to be careful out there.
Oh, I agree. You got to be so careful. So deadly sin number 6. Always be thinking about the competency of the client and beware of falling into a trap where you do something because you have failed to consider the competence of the client. Let me give you an example. I'm aware of a case over on the west coast of Florida where a few years ago, a young lady had been in a tragic accident and was severely brain damaged. She gets out of the hospital, goes into a rehab center. After the rehab center, somehow finds her way to a law firm. The plaintiff law firm brings her in, signs her up, and writes a demand letter. And in the demand letter says she's cognitively destroyed. She has no memory. She can't think. She has difficulty speaking. She can't concentrate. She can't focus. We're considering getting her setting up a guardianship. She can't put sentences together. And yet, that same lawyer had her sign a contingent fee contract. What gives? If you have a client with a brain injury and you are saying there are serious competency issues, you have to take other steps beyond having a client sign the contract. It may be you have them examined for purposes of competency and get a document signed by a physician. It may be you have to get a guardian appointed. It may be you have to get court approval. It may be many things. All I'm saying is, don't take the position that there's some severe brain injury and you have them signing contract documents. Be very, very careful of that. All right. Finally, deadly sin number 7. Failure to know and follow the rules. Now, in Florida, we have a very, I think, straightforward rule about contingent fees. And I think most everybody, at least from Florida who's listening, understands this. And I know we're nationwide, but here's how it works. There's a presumption in Florida that if you're signing up a personal injury case, and let's assume you're going to be filing suit, that your fee can be 40% of the first million, 30% of the second million, 20% of anything above that. In certain cases, like a product liability case, though, our firm won't do it unless there's a 40% across the board. Our rules say if you're going to try for that higher fee, you have to follow a procedure by having an evidentiary hearing, in essence, with a judge, and a judge has to sign off on it. And we do that on a routine basis in product liability and medical malpractice cases. Don't ignore that rule. In every state, you have rules somewhat similar that deal with whatever it is, fees, costs, dispersing money, the way you handle cases, all sorts of things. Know the rules, follow the rules, and never take advice from some lawyer. I just heard this recently from a lawyer in Florida who says, you know, in our firm, we don't even pay attention to that rule. We just sign them up on a 40%. I said, you know what? I can't believe you just said that to me. I told him, I said, you can't do that. There was a case many years ago in Florida, South Florida, of a lawyer who did not comply with our contingent fee rules. To make a very long story short, the judge ultimately voided the fee contract. And on a case where they were ready to disperse big money as a fee, they got nothing. So the counter was, oh, all right, well, we're at least entitled to a fee based on quantum merit. And the judge says, read my lips, no fee. Because if you fail to follow the contingent fee rules, that's misconduct. So be very careful about that. Anyway, that's a quick hit on my 7 deadly sins.
John, if I can go back, I'm looking at, the fun part about Connectionology, Andrew, we have people from all over the country, and we also have people outside of the country who come in. But I'm looking here, I see 2 stalwarts from the Midwest today. David Ranson, John, from Missouri, is on. He's a great teacher and just won a fine award from his Trawlers Association in Missouri. He's on board. And then we have Jerry McGrail in the Illinois Basketball Hall of Fame. We've got some Midwesterners here, John. Who are,
oh my goodness.
yeah.
Well, I know both of them, and they're
and then I see Danielle Martins is on, who used to be in Colorado and Florida, and she's kind of like this paralegal who you never know where she's going to be, but she's working all the time, John.
No, I know
So-
where I think she usually is in the Colorado mountains.
Right. Always working though, looking for justice, seeking justice. And on that, the lack of communication with clients, last point before we move on, John, I agree with what you say, which is, let me get this thing, it should be on silent. If you're trying to develop your case, if you really want to be successful, you say, listen to your client. Your client will make the case for you. And I think we as lawyers get so busy, we want to go in there and talk about things with them and be dictating everything. You've always been a proponent. Take that time to listen to your client. Give them the time they need. They're nervous. They don't a lot of them don't have any experiences with lawyers. I'm the first lawyer in my family, so, it's getting into law was something new to me. It's a different thing. What do you think, John?
Yeah, no, I agree with you, Doug, and I want everybody to remember this. Quote, your greatest co-counsel is your client. End quote. I know you already heard it, but I'm going to say it again. Your greatest co-counsel is your client. You can learn so much by spending time with your client, which again is why I recommend, I know you can't do it in every case, but as much as you can, visit your client on your client's turf, where they work, where they live. Okay? If you have a wrongful death case and being very sensitive about it, you want to go to the home and actually go into the bedroom of where that person lived to see how the room was decorated and those sorts of things. But to me, that's very important. But I want to give you an example, and Doug will know all about this because this goes way back to 2012 in the first case that Doug and I tried together. And we tried a brain injury case with Liz Zweibel and with Riley Bean and with Dustin Herman, who's now up in Cleveland. But the family we represented, the mom and dad had some domestic difficulties pre his brain injury. And part of the discussion on the team was because the police had been called to their home twice pre-brain injury incident, perhaps we should dismiss the spousal loss of consortium claim. We also have the claims for loss of consortium for the children, which are called parental loss of consortium. It's filial loss of consortium when you have a child injured and the parent is trying to recover for the parent's pain and suffering over the injury to the child. So we're all talking about it. And it started to seem to me like it would be a good idea to drop the spousal consortium claim. For many reasons, we don't have time to go into it now. We then sit down with Dr. Harvey Moore, our litigation and trial consultant on the case. He has a PhD in sociology, and I've tried up to that point lots of cases with him. And I told him what we were fixing to do. And in no uncertain terms, he got in our faces and was saying things like, I thought I was dealing with lawyers who had courage, except he used other verbiage to make his point. And he said, I think you're going to end up with jurors that are very mature. And remember, although they had problems pre-brain injury, she insisted that they go to marriage counseling. They did. And they've continued the marriage counseling right through the brain injury, post-brain injury, right up until the trial. He said jurors will have great respect for that. I said, okay. So we talked about it. We made an agreement. We keep the spousal consortium claim. We did. And I will just tell you, the jury, in terms of the actual compensatory damages award, they gave the spouse, the wife, $10 million on the consortium claim, when the husband, for the main brain injury part of the case, I know the children received some and I forget the exact amounts, but I think the husbands came to about 14 or 15, maybe a little higher. But I thought it was rather remarkable because Dr. Moore took Doug Beam and Liz Weibel and John Romano back to school. He schooled us and taught us a lesson, and we learned from that. And the great thing about what we do as lawyers, we learn, it never stops. And you must always keep an open mind, and don't ever reach the point where you go, well, you know, if it ain't broke, don't fix it. Forget that. There's a great book you can buy, by the way, and the book is entitled, If It Ain't Broke, Break It. And the key is keep an open mind. Doug, it looks like you're getting ready to say something.
Well, I agree 100% with you. And I think in that case, and we're going to segue into intake, case selection, John, and kind of hit some of these points as quickly as we can with the time we have left. But that case, I clearly remember the wife coming in to see me, and I believe we were the 12th law firm she had consulted with. And let me tell you, the other 12 law firms she talked with all were good lawyers. I mean, solid. They just did not like the case. And John, you'll know why we took that case. She looked at us, or me at that time, we hadn't joined forces, and she said to me, "You're our lifeline. If you say I don't have it, we're not going for it." I said, "We're only 2 months away from the statute of limitations running." I said, "I'll tell you what I'll do. I believe in your cause. We're going to file it, do the best we can to name all the parties. We'll do what we can to help you." And at that point, she was so appreciative, and the jury got it. The jury got it.
Oh, yeah.
Justice was done. But you had to listen to the client. It was a very tough case, but the children, I think, may have gotten about several $1 million, also in addition to the spouse. But one thing I did want to touch on, John, something you said about preparation earlier. Abraham Lincoln once said, "Give me 6 hours to chop down a tree, and I will spend the first 4 sharpening the axe." There's a lot of truth to that. John, trying cases is hard work, and being a lawyer is hard work. It's a reason it's such a privilege to do it, and we should all take that seriously every day. We get to do things that so many other people don't get to do. We worked hard to get here, but we have to work all the way. And when you go to being prepared, preparation, being organized. John, I like the concept of a daily top 3. At the end of one day, you think about what I have to do the next day. You put the 3 most important items you have, and unless there's an emergency, you take them one at a time the next day, and you knock them out. And I advocate that. I will tell you, John, I feel lonely sometimes. I can't get people to do that sometimes. I'll say, "Come on, we have to think." You don't go to the airport, John, and the pilot shows up and she says, "Well, I'm here. Where are we going today? Hey, hey, look, I got all these people here. Let's get in the plane and take a little flight today. Where are we going to go?" No, they have a flight plan. You know, this.
Yeah, no,
Yeah.
it is tough. It is hard. It is stressful, but I have great news for everybody in litigation and trial. It's supposed to be stressful. If you don't want stress, for God's sakes, don't be a trauma surgeon. If you don't want stress, don't be a Marine Corps fighter pilot. If you don't want stress, I mean, I could go through a whole bunch of things. I don't want everybody to drop out of your chairs when I say this, but there's bad stress and there's good stress, okay? If you're an NFL quarterback and you are driving down the field, it is tremendously stressful, but that's good stress, okay? Bad stress is when you're worried about the health of a child. your spouse's health, or that your family's out of money. I mean, those kind of things, I don't want anybody to ever have to go through, but they're gonna be tough things. The stress that I'm talking about it's stress that we begged for when we became trial lawyers. We begged for what we do. When you say, I want to be a plaintiff's lawyer, I want to take depositions, I want to go to mediation, I want to go to trial, I want to be in front of judges, I want to argue motions, I want to be in front of juries, I want to be in front of appellate courts, you are begging for stress. But it's the kind of stress that invigorates you. It's the thrill of what we do. And whatever we do, while engaged in that activity, you got an arm around your family and you got another arm around your client, and you're marching forward. And guess who's right in front of you? Client, family, and right in front of you, your staff and all the people in your law firm, and you're marching forward. So that's how I envision it. I'm not good at drawing, but if I was drawing it, I'd draw a painting right now of how I envision that.
Well, John, you mentioned failure to explain. I think sometimes we talk, I know you served in the military. We have people here on the Space Coast, they speak in acronyms. We talk to clients and you all of a sudden start going, well, let's see what your BI coverage is. Then you might have some I don't know. Let's look at your property damage. And in Florida, we have no fault. That's called PIP. We got to look at that. And then we have set-offs, and then we have liens we have to deal with, letters of protection and all this. And the client's looking at you and you think they're being polite, they're listening, like, you're not. The real skill set is, Thoreau said, John, simplify, simplify, simplify. My response to that is, why did he say simplify 3 times? He should have just said simplify. But anyway, you need to break it down like you're a news writer. Don't use an acronym till you define what it is and explain what it is. The real skill for the best trial lawyers I've observed is, I like the concept, as you know, John, I like to talk, and you do too, and other courtroom storytelling, 6 words or less. That's 6 words. If you can distill a concept to 6 words, it's tough, but you get to the essence of it. If you're really thinking about your case, you'll distill it. You'll be able to simplify it and be able to explain it. And I say all this because it does tie into ethics and professionalism, because you want to be as effective an advocate as you can for your client. Well, John, one thing I'm going to touch on. We talked about
Wait a minute. I gotta interrupt you a minute. I'm guessing there's no such thing as a 6-word story has ever been written. You just talked about a 6-word story, so I'm giving you a softball.
Okay. Well, you must be thinking about.
Has there ever been a story written in 6 words?
Well, what we're talking about, John and I use this this story. It's probably maybe apocryphal, but Hemingway and some writers were around a table and they challenged each other. We're going to have a competition. Who can write a short story in 6 words or less? So they had this competition. They went off. They thought hard about how to do it. And Hemingway won the competition. And here's how he won it. And John, every time, as often as we talk about this with lawyers and I hear it, I get goosebumps every time I say it. Sometimes I weep, depending on where I am emotionally, but it always moves me and I treat it with great reverence. Here's Hemingway's 6-word story. I didn't know you were going to bring this up. I didn't know I was going to bring that. Child's shoes for sale, never worn.
It's unbelievable how he could do that in so few words. It's just, I don't know, it's remarkable and it's beautiful, but often the greatest stories, they take you right there. So
yeah. So thank you for mentioning that. And I'm glad to hear that, and I think
May I,
yeah,
may I mention one thing, Doug?
sure, John.
There are two cases that deal with the ethics of using AI, including ChatGPT, that you should take a look at for some level of guidance. One is called Matter of Samuel, and that is January 11th, 2024, in the Surrogates Court of New York, Kings County. And the other case is Mata, M-A-T-A, versus Avianca, A-V-I-A-N-C-A, Inc., 678 Federal Supplement, 3rd, 443, and that is June 22nd, 2023. And I'll just tell you briefly what they deal with. Where the attorneys were sanctioned in the Mata case with using fake quotes and citations, which had been created by ChatGPT. The court emphasized how the harms caused by such submissions, including wasted time, effort, and money, and potential harm on the reputation of judges and courts, and promoting cynicism about the legal profession. If you take a look at those cases, you'll just see the lawyers just tried to take a shortcut and use AI without following up and confirming or verifying the correctness of the legal citations. One of our young lawyers here just came in a little while ago. At a meeting a little while ago, told us she's working on a project, and AI cited 2 cases with actual citations, by the way, that don't exist. So you have to be careful with those things. You know, ChatGPT can be very helpful, and we are using it in our practice. We're using other forms of AI, but be careful. That was it, Doug.
Well, I'm glad you touched on that. So the one thing I was going to say, and we can move through this point fairly quickly, trust accounting. There's a reason it's called a trust account. You know, people trust us with their money every day in our country. Millions and millions of dollars, if not billions of dollars, are moved through law offices throughout the country on basically a handshake or an email. Money sent, it's supposed to go into your trust account. Don't be tempted to do something funny with that money. Don't do it. You must have your trust account balanced to the penny, no matter where you are financially. Don't dip into that trust account thinking I'll put the money back in later. Don't do it. That is the quickest way to lose your license or be suspended and have a permanent mark on your record, or one of those or the other, and be criminally prosecuted. Don't do it. If you get in dire straits, reach out to a lawyer in the community. There are other ways to handle that. Just don't do it. That's the trust account. But John, we're talking here. I think Ginger has some more information for us.
I sure do, guys. And I've been enjoying hearing all of this information. But we're going to take one more quick break, and then we're going to jump back into the presentation. I wanted to bring in 2 more of our incredible partners. The first one is going to be Miss Laura with HMR. And as you guys know, we've been working with this company for many years now. They are fabulous, and she's going to share with you some of the more specific information that they can do to help you guys and your clients as well. But Miss Laura is going to jump in here right now, and it is great to have you with us today.
Hi there, good afternoon. It's good to see everyone. For those of you who maybe are just joining and you're brand new to Connectionology, HMR Servicing is so honored to be a part of this program, and we have been now for several years, which is really neat to be able to say. We are a funding company that works nationwide with personal injury attorneys and their claimants. That's all that we do. Our programs are designed and tailored to every need that you have and that your client also has. So let me just tell you real quickly, we're offering to help with medical care from day one. Sometimes we're involved in the very first moment of setting up a consult. We follow that medical care all the way through, punting it back and forth to you, the law firm, to see, are we still needed here? Do you need us to consider funding this additional care plan? A lot of communication going back and forth. Sometimes we're coming in at the end of a treatment plan where the journey has been worked up to now there's a surgery that's needed, or now we have a post-concussive traumatic brain injury plan that needs to be considered, and there just isn't any money for the family or the individual to fund that themselves. So we're used to jumping in at any stage of the game on your cases to do what we can. Along that path, we are assisting your client with cost of living needs. Do they need funds to pay their insurance? Do they need funds for mortgage, for car, for children in college? Whatever it is, we look at that need, we underwrite it, we talk to you as part of our underwriting, and we come up with that plan together. The neatest thing that we're doing now, and it's grown to be a big part of our business, probably larger than we anticipated. We are offering direct to law firm expert case cost funding. So all of your expert testimony, all of your expert visuals, all the things that you need to take that case to trial, we're able to still partner with you and make sure that you have those funds. I think of a case where we had been involved in a simple spine consultation, and then there were some injections, and it wasn't really moving forward with anything more than that. Once this attorney in Memphis took the case, to the point of deposition, it was determined that his client hadn't said anything, but had been suffering from severe depression and severe post-concussive migraines and so many things. His vision had even been suffering. But as we know, a lot of your clients don't always complain, or maybe they said something to your paralegal and maybe it didn't get to you. But we were able to go back, get re-involved in that case, and fund that much needed neuropsych evaluation and then actual TBI care with a team of experts and different therapies. I love today's topic, and I'll be super brief. You're talking about ethics. I think that's a fan favorite at the end of the year, John. I think you're wrong. I think people love this topic. And I would just leave you with everything that we do from the moment that you log onto our website. You can create your own password as an attorney, as a paralegal. You can send us your case details and any supporting documentation very confidentially, very securely. We know everything is so important, and every communication we want to have with you, we are keeping that in consideration. So, we know that things can be subpoenaed. We're very conservative. We want to do right by your case, right by your client, help you prove those damages, and help you win that award that they deserve. So I have the most important thing, our website. It is there. Let me just send it here shortly. If you log on there, you're going to see lots of testimonials, lots of different cases that we've been involved in, and I just encourage you to look at that. Thank you.
Hey, thank you, Laura. That was great. And as you know, we love working with the folks at HMR. We've got cases going on right now. We've been working together for many, many years. But as I've told folks just recently, Kyle sat down with me and with one of our clients who you all are working with, and she said it was just a remarkable and warm experience because of the way that he walked her through everything having to do with the funding, how it works, timing, duration. Kyle, meaning HMR, made sure that you understood everything about the case, the medicals in the case. You already know about our firm. He wanted to learn a lot about her, and that personal touch that HMR brings to the case, in addition to a wealth of knowledge, competency, skill, and talent, it makes all the difference in the world. So we love working with HMR. You all are wonderful.
Thank you for that. That's so kind. Thank you for letting me have time to speak during your presentation.
Absolutely.
We love
Thank you,
we
Laura.
love you all.
Thank
you.
you. Thank you so much, Laura. And please put your information in the chat box so that way everybody can stay in touch with you. Did you want to go ahead and, by the way, since we have you, announce the winner of today's coffee giveaway?
Oh, I would love that. Thank you for reminding me. So HMR is happy to be giving away 4 bags of wonderful, I believe it's Ethiopian coffee. I can't pronounce it. But today's winner is Quack Fam out of Roseville, California. So congratulations, Quack
Yay.
Fam. Yes.
This is wonderful. Thank you so much, Laura. And big thanks. I know Ted wasn't able to be here today to announce it, but thank you for doing the honors for us. And don't forget, you guys still have more chances to win more coffee at all of our upcoming webinars. So thank you again so much, Laura. We appreciate everything that you guys do over at HMR. And this is always the highlight and the treat of the webinar. So thank you.
You got it. Thank you.
Thanks, Laura.
All right. And then you guys, guess who else is here? We got Samantha from Strategic Relationships. You guys know I rave about this company too, because they are doing things that nobody else is, and they can literally go and find the people that you can't. So Samantha, I'll let you do the honors, but it's great to have you with us.
Yes, and Laura, we have a lot of our clients that HMR actually funds the research. And so HMR is doing a lot to help attorneys, especially when they're trying to build a case. And that's exactly what we help you do. We help you build a really strong case by finding you former employees that have the insider information that can just blow your case wide open. And you can also turn these informants into witnesses. These are all former employees, and we've been in business for over 20 years and never any ethics violations or anything. All of our information has been admissible. So we take that very seriously because we know what's at stake for you guys. Like I said, we've been in business 20 years, no ethics violations of any kind. And so it's just another tool in your arsenal. It's not for every case. It can be about just under $8,000. So it's for the right case, it's an excellent tool to find former employees to help you build your case. And if you have if you'd like more information, I'll put my contact information in the chat, and we'll see you guys in Fort Worth in just a couple of weeks, 2 weeks. So we're excited to see everyone, discuss your cases, and just explore and brainstorm whether this is a viable option for your case to build it. So I'll go ahead and put our info in there, and I'll see you guys in.
Can you, the ill is real.
Yes.
What's that acronym, ill? Tell us about
Yes,
that.
more acronyms. So it's ex-employee list. These are real people, former employees. We actually, when we get on the call with them, we make sure that they're former employees and that they're not under NDA. And we follow all the ethics and all the rules that you guys, the NDA non-disclosure agreements.
You call it, yeah.
Yes, yes. So.
And that's something you work with the lawyers on, kind of brainstorming on who these people might be. And then they prepare it, get it to you. And then, as you say, you, Paul, the team, you look into that, keeping in mind, you're going to keep it above board. You're
Absolutely.
not going to get anyone into any trouble. And yet, I know John knows, and we've talked to Paul, it's remarkable your results over the years by just how you talk with people and prepare your documents. You're very careful.
Yes, we are. And I think that's the value of having so much experience and working with one-on-one with the attorneys on very fact-specific cases. And so reach out if you have a case that you think it might help. And we've done so many of these cases that we can tell you, even expand your search as far as job titles. Sometimes people come looking, I'm looking for just the lab, or I'm just looking for HR, and we will, you know, so in our experience, also these people might have more information. So we're able to do that for you.
All right.
Samantha, all I can tell you is this. We started working with Strategic and with Paul back, I think, in 2009,
Wow.
in a couple of dram shop cases where he performed miracles and found bartenders that
Mhm.
we had been told had left planet Earth, and he found them. And what you all do is really you pull off minor miracles. I want everybody to know that I was contacted about 2 years ago by some lawyers in the Northeast on a case project they were doing. And I said, you need to call Paul and his team. They did. They hired you all, and you found them a number of former employees who were the equivalent of like whistleblowers on that company. And it has turned everything around for them and for that case. And you all do it time and time again. And I think the work is just extraordinary. I've never once asked Paul, how do you do it? I don't want to know. I just think it's really extraordinary. We love working with you. And everybody there at Strategic has always been so responsive to us, gets right back to us. The pricing or the cost makes such good sense. So we love working with you, and we're going to keep working with you.
And just so you, for peace of mind, what we do is we have ex-CIA, ex-military investigations, and people with tons of experience that have special licenses and access to indexes. And so this is why we're able to do what we do, and we know how to access these public records and keep everything ethical and protect your license. So this is why working with us with all this experience matters.
Thank you.
Thank you.
Fantastic.
Thank
Thank you,
you.
Samantha. And please put your information in the chat box again, because I know that everyone's going to want to save this and reach out to you. So thank you.
Thank you, Samantha. Well, John, in our time left, just looking at our screen here. Are we good to go, Ginger?
Yep, you're good, Doug.
Okay. John, how would you like to approach? I have something I always like to share with the lawyers called creative approaches to protect yourselves and others. And if I may run through those, John, if that's okay with you.
Yeah, that'll be great.
Okay. All right. Number one, I think this is a great thing for lawyers, no matter where you are in your career. Join and participate in your local voluntary bar association and local, state, and national trial lawyer groups. That would be your local, like here in our county where my office is, Melbourne, Brevard County, Florida. We have the Brevard County Bar Association, and it's wonderful to get involved in that, particularly as a young lawyer. You get to be around top lawyers, lawyers who practice in different areas of law. Judges don't get to go out a lot sometimes in the community and relax, but they can come to a bar meeting and you can sit at a table with veteran judges and get to know them and learn so much. And as far as your state bar, trial lawyers, let's talk about that. Join the American Association for Justice nationally. Join your your state court counterpart in Florida. It's the Florida Justice Association. And also, I think you'd very much enjoy the National Trial Lawyers. It's emphasis on education and networking. And we have the summit coming up in January 2025. Probably have 1,500 or more lawyers there. Great education programs. You'll hear John Romano and others. It's going to be a great event. Look at National Trial Lawyers online and consider joining that. Another thing you can do, John, is you can serve on a grievance committee. And that is a wonderful way to serve the community. It's a tough assignment because candidly, some of the things you see, but by the grace of God, go I. You'll learn a lot. and states usually try to have lay people on those committees too. So you would be have the opportunity to work on those. You get to know the rules regulating your state bar. You get to conduct investigations. And I was fortunate enough to chair the local committee. And then practice pointer, you may have to sit out a year or two after being on the committee, but then you can defend lawyers who are being investigated or prosecuted by the bar. I would also encourage you to consider representing fellow lawyers who are under investigation or being prosecuted by your state bar association. It's a good way to help the other lawyer, and that's important. And by the way, if you get a grievance, don't immediately write a response in anger. Write your response. I'm talking about Abraham Lincoln again here, but Abraham Lincoln was said to have gotten letters from angry constituents, and he would write his response and then he would put it in a drawer to let them cool off before he sent it. And they said after he was assassinated, they opened the drawer and there were many letters that were never mailed because he had thought better of it. So get with someone. If you get a grievance, get with the senior member of the bar, someone who's chaired the grievance committee, maybe a former judge, somebody who has the respect in the community to represent you. Consider serving on a bench bar liaison committee. Again, that's a wonderful way to bridge the issues that confront the bench and the bar. The other thing you should look at, if you have a friend or you have an issue with alcohol or other drugs or emotional issues, there are lawyer assistant programs, just like doctors have. And it's very important to know about those and avail yourself of that. Or if you know somebody, because if you can get into that program early, you can avoid some of the sanctions that are out there. Some people don't know this, John, but when you buy your professional liability insurance, there's usually a provision in there that if you have a grievance filed against you, they will provide representation. And generally a pretty large amount of money in your policy can be devoted to your defense in the grievance. Also, of course, if you're sued, they'll provide you with legal counsel. Keep in mind too, if you refer a case in a personal injury context, you're on the hook for malpractice. So when you refer a case, take it very seriously. Just don't willy-nilly send people out. You can be on the hook both for malpractice and a grievance if you don't do that. Be careful. Also, a marketing approach. If you've been when you have malpractice coverage and you've been handling referrals for years, that's a wonderful marketing approach and gives attorneys a peace of mind to know when they refer the case to you that you have coverage in case there should be some mishap in the representation. Retain a top certified public accountant. Keep your trust account clean, balanced to the penny, and get a top banker. Mark Twain said a banker is someone who'll give you an umbrella on a sunny day, but won't give you one on a rainy day. But if you find a top banker and get your relationship, that banker can be a huge boost to your practice and you don't get in financial straits. Also, fundamental, John, I know how your Romano Law Group is. Here at Douglas R. Bean, PA, we feel you should give back to your community. People pay attention when you're in the community. Go give talks to your local Rotary Club or League of Women Voters or things like that. Give them a talk. These organizations have to put a program together every month, and they need a speaker. So get out there and talk to them and let them get to know who you are in the community, because a lot of people don't know lawyers, but they'll appreciate you coming out and talking on a legal topic for them. Consider coaching a mock trial team at a local high school. All of these things help improve your reputation in the community because, John, as many jury trials as you've tried, I mean, you're a Hall of Fame trial lawyer. I've heard you talk in recent years more and more, not only about jury voir dire and the importance of preparing for that and using someone like Dr. Moore, other people, Beverly Abbott, other people in the field. But I've also heard you start talking more about the importance of the judge. How important is that? Your credibility with the judge, first of all, when you go in front of that judge and they look you in the eye and say, Mr. Romano, is that the law? How have you seen that done? Or at trial, they know you're credible. You have a track record. You could be a young lawyer and still be highly regarded. And they trust you, don't they, John? So can you add a little bit on that? And then I'm going to give you can bring it home, John, after that, whatever you want to say.
Here's the key is this. When I was given a lecture about 20 or so years ago, and a young lady raises her hand and she says, John, what is the most important part of the trial? I said, the judge. And she said, oh, no. What I mean is, what is the most important aspect of the trial? Like, is it voir dire? Is it opening? Is it cross? I went, oh, okay. It's the judge. And a lot of people chuckled, and I said, look, the judge controls everything because of the way jurors look upon the judge. And I now say to people, watch the series, Your Honor, starring Bryan Cranston, because in the first season, there is an episode where, because he's gotten involved as a judge with the wrong people, and the mafia wants him to throw a case. The mafia boss is very angry with him because of a ruling he made, which they think will hurt their side. And after they try to beat him up a little bit, I mean, literally, he then basically puts his finger in the chest of this mafia boss and says, look, you know your business, I know mine. But when I'm in that courtroom and I am the judge, everything I want to have happen will happen. It is I, as the judge, who molds the jury. And in one case, I can make them acquit someone who's guilty. In another case, I can make it go the other. Anyway, it's a very powerful movement in the series. And yes, I recognize it's Hollywood and it's a movie series. But to me, it's so important for us to think about, because judges do have a power that a lot of people don't think about. So you want to do everything you can to let the judge know how much you care, that you can be trusted, you can be believed. I've seen judges reading jury instructions, and they're holding the jury instructions up, and the judge will go, if you believe in this case there was wrongdoing, I'm exaggerating, but the jurors understand, okay, the judge believes there's been wrongdoing. And again, I'm overstating the point to make a point, but that happens in real life. And you need to know that your job is to do what you can for your client. Your job is to be truthful and credible with the jurors, truthful and credible with the judge. But to be truthful and credible, the judge must trust you.
Well, John, thank you for that. We have many other, as you know, we prepare for these things. We have pages and pages of other material we can go over on this important topic. But I think we have our time. I think time's here, 5 p.m. Ginger, I see, by the way, John, I see Dr. Biff Pettingill, one of the most preeminent economists, has attended today to listen in.
I would consider him the single greatest economist that I have ever seen in the courtroom. And I've seen multiples of dozens. And he is not only just brilliant in terms of his field as an economist, but he is an extraordinary witness when it comes to preparation and explaining his testimony to judges and juries. He also happens to be a very funny guy.
Hey, John, what's coming up with Connectionology? We have a program in Fort Worth that is off the charts good. I don't know if there are any spots left. Can you help us with that, or Ginger? Tell us about what's going to go on in Fort Worth.
There could be like maybe 1 or 2 spots left. I mean, we are pretty much almost full right now because we were taking a limited amount of attorneys with us. So that way everybody could be in these small, intimate deep dive sessions each day. And it's actually starting next Wednesday. We're all going to be flying into Fort Worth. And then on Thursday, Friday, and Saturday, we've got 3 days of great learning with all of these amazing speakers. And I would just say, if you're interested, now's the time to do it. And you might still be able to get like a really good flight. I know if you're in Florida, you can get usually direct flights into Dallas, and then 30 minutes away is the Stockyards, which is probably one of the coolest places I have seen in the last few years. It's pretty much a very special place. Think of like Nashville, only a little cooler. And you know we love Tennessee, Doug.
I know that. So let's see, we have Fort Worth, Depositions at Trial, and Satch Oliver, who just wrote a book, Depositions at Trial. And we have a dynamite faculty out there for that. And then we have in the spring, we're going to have the traumatic brain injury Nashville Connectionology, which is just growing leaps and bounds. I mean, people just look forward to that, and it's so much fun, and we learn so much. And so we have that one coming up. So when you're looking at your calendars for next year, we all plan ahead. Look at the Nashville TBI. It should be up on our website. Also look at National Trial Lawyers Summit. That's coming up in January. You can get in. It's a great time of the year to be in South Beach in Florida, and you're going to hear premier trial lawyers from around the country talking. And as part of that, a bonus you get for signing up for NTL Summit is you get Ethics Palooza in advance. So you can, we're going to have many, many speakers on that, and you're going to enjoy that. So that just wanted to throw that out there. There's so many great things. And John, thank you again. I just very much appreciate it. And Ginger Jarrett here does a fantastic job, and we really appreciate you, Ginger. So I'll stop the Mutual Admiration Society now meeting. So thanks, everybody.
Well, and thank you, Doug and Ginger. This has been really a lot of fun, and I'm glad we were able to do it.
It is such an honor to have both of you guys with us, and I can't thank you enough for being here to help teach everybody and to make it very fun and entertaining as well, because it's a very important topic, and it's something that everybody needs to know about and continue learning about. They learned a lot of new things from you guys today, and I know that we're going to have a lot of great comments after this. Just wanted to remind everybody that to reach out to me if you're interested in getting CLE credit. You watched the entire webinar today, and I'll make sure that we work with you on getting that done for each of your states. But thank you to all of our incredible partners, HMR, Fox AE, OnPoint, and Strategic. We could not do this without you guys. And again, thank you so much, Doug and John. We appreciate everything that you guys do day in and day out.
Thank you. Seek justice, everybody.
Bye, everyone. Have a great day, and we'll see you back in November after Fort Worth with some more webinars. Bye, guys.
See you. Seek justice.